For over 150 years, if you were born on American soil, you were an American citizen. No questions asked. No exceptions. But right now, 9 justices are deciding whether a single executive order can erase that guarantee forever. And what they decide will reshape what it means to be American. Welcome to Court Decoded. Today, we cover the landmark Supreme Court challenge to President Trump's executive order on birthright citizenship and what the 14th Amendment actually guarantees. On January 20th, 2025, just hours after taking office, President Donald Trump signed Executive Order 14160. Its target, birthright citizenship. The order directed federal agencies to refuse recognition of citizenship for children born in the United States to mothers who were unlawfully present or whose fathers were not citizens or permanent residents. Within days, the ACLU and a coalition of civil rights organizations filed suit. Multiple federal judges issued immediate injunctions, blocking the order before it could take effect. But the administration pushed the case directly to the Supreme Court, arguing the matter was too urgent to wait for lower court proceedings. The speed was unprecedented. The stakes were even higher. For the first time in American history, the executive branch was asking the courts to narrow the meaning of the 14th Amendment's Citizenship Clause. The question before the justices was deceptively simple. Can a president, through executive order alone, redefine who gets to be an American? The words at the center of this constitutional battle were written in 1868. The 14th Amendment's first sentence reads, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." 28 words. They were crafted in the aftermath of the Civil War, specifically to overturn the Supreme Court's infamous Dred Scott decision, which had declared that Black Americans could never be citizens. The amendment's authors wanted no ambiguity. Birth on American soil would guarantee citizenship. No act of Congress, no state law, and no court ruling could strip that right away. But the Trump administration's legal team focused on 5 words within that sentence, subject to the jurisdiction thereof. They argued these words created an exception. Children of unauthorized immigrants, they claimed, were not fully subject to American jurisdiction because their parents owed allegiance to foreign nations. It was a reading of the Constitution that had been rejected for over a century. Until now. The oral arguments unfolded over nearly 3 hours in the marble chamber of the Supreme Court. Solicitor General John Sauer presented the administration's case. His argument centered on original meaning. The phrase "subject to the jurisdiction," he contended, was understood in 1868 to exclude persons who owed allegiance to foreign sovereigns. Children born to unauthorized immigrants, under this theory, inherited their parents' foreign allegiance and therefore fell outside the amendment's protection. Justice Ketanji Brown Jackson pressed Sauer immediately. She noted that the same Congress that passed the 14th Amendment also passed the Civil Rights Act of 1866, which explicitly granted citizenship to all persons born in the United States, not subject to any foreign power. The administration's reading, she suggested, would require ignoring what the amendment's own authors believed they were doing. Justice Amy Coney Barrett raised the practical implications. If the executive branch could redefine constitutional terms through executive order, what would stop future presidents from narrowing other fundamental rights? Anthony Romero, arguing for the ACLU and the coalition of challengers, opened with history. He walked the justices through the congressional debates of 1866, where Senator Lyman Trumbull, the Citizenship Clause's author, explicitly stated that subject to the jurisdiction meant subject to American laws. Anyone who could be prosecuted for a crime on American soil was subject to American jurisdiction. By that standard, every person physically present in the United States, regardless of immigration status, fell under the clause's protection. Romero then addressed the lone Supreme Court precedent directly on point. United States v. Wong Kim Ark, decided in 1898. In that case, the court ruled that a child born in San Francisco to Chinese immigrants who were legally barred from ever becoming citizens was nevertheless a birthright citizen. The court's reasoning was unambiguous. Birth on American soil combined with being subject to American laws, conferred citizenship. The parent's status was irrelevant. Romero argued that overturning this precedent would require the court to reject 127 years of settled constitutional understanding. Chief Justice John Roberts asked the question that cut to the heart of the separation of powers issue. Even if the administration's interpretation of the 14th Amendment were correct, did the president have authority to make that determination unilaterally? Constitutional interpretation, Roberts noted, had traditionally been the province of the courts, with implementation left to Congress. An executive order redefining citizenship seemed to bypass both branches entirely. Justice Neil Gorsuch, often an ally of executive power, appeared troubled by the mechanism. He pressed sour on whether this theory would allow any president to issue executive orders reinterpreting other constitutional amendments. Could a future president declare, by executive order, that certain speech was not protected by the First Amendment? Justice Clarence Thomas, typically silent during arguments, asked a pointed question about reliance interests. Millions of Americans had been born under the current understanding of birthright citizenship. What would happen to their status if the court adopted the administration's reading? Throughout the arguments, the shadow of Dred Scott loomed large. Justice Sonia Sotomayor invoked the 1857 decision explicitly, noting that the 14th Amendment was written precisely because the court had gotten citizenship catastrophically wrong before. The amendment's authors did not trust future courts or future Congresses to protect the citizenship rights of vulnerable populations. They embedded the guarantee directly in the Constitution's text. The administration's attorney attempted to distinguish the cases, arguing that Dred Scott was about race, while the current order was about immigration status. Justice Elena Kagan responded sharply. She noted that the 14th Amendment's language made no distinction between races or classes of parents. It spoke of all persons born in the United States. If the framers had wanted to exclude children of certain immigrants, they knew how to write such limitations. They chose not to. The historical record, Kagan suggested, showed deliberate, inclusive language designed to prevent exactly the kind of narrowing the administration now proposed. Beyond the constitutional abstractions, the case carried devastating human implications. If the executive order took effect, an estimated hundreds of thousands of children born in the United States each year could be denied citizenship. They would become stateless persons, belonging to no country. They could not obtain passports, could not vote, could not access federal benefits, and could face deportation to countries they had never seen. The challengers presented evidence of the chaos already created by the order's brief existence before injunctions halted it. Hospitals reported confusion about whether to issue birth certificates. Parents described being told their American-born infants might not be recognized as citizens. State officials expressed uncertainty about which federal guidance to follow. The administration argued these were implementation details that could be resolved later. The challengers responded that constitutional rights could not be suspended while bureaucratic kinks were worked out. The harm to affected families was immediate and potentially irreversible. Supreme Court observers noted that even the conservative justices appeared skeptical of the administration's broadest claims. Justice Brett Kavanaugh asked repeatedly about limiting principles. If this executive order was valid, what constitutional interpretations could not be made by presidential decree? The administration struggled to articulate clear boundaries. Justice Samuel Alito, while appearing more sympathetic to the government's textual arguments, expressed concern about the practical administration of a two-tiered citizenship system. How would hospitals verify parents' immigration status at birth? Would children's citizenship be conditional pending investigation? These operational questions suggested the justices were taking seriously the real-world unworkability of the order. Legal scholars watching the arguments noted that the court seemed most troubled not by the underlying constitutional question, but by the mechanism of executive action. Several justices suggested that even if Congress might have authority to define the jurisdiction clause more narrowly, a president acting alone almost certainly did not. As the arguments concluded, Both sides acknowledged the magnitude of the moment. A ruling for the administration would mark the first time in American history that the Supreme Court narrowed the scope of birthright citizenship. It would grant the executive branch unprecedented power to reinterpret constitutional text. And it would affect the citizenship status of millions of people, both future children and potentially those already born under the current understanding. A ruling against the executive order would reaffirm the century-old consensus on birthright citizenship, while establishing clear limits on executive power over constitutional interpretation. The court is expected to issue its decision before the term ends in late June. Whatever the outcome, this case will be studied in law schools for generations. It tests the boundaries of executive authority, the meaning of constitutional text, and the fundamental question of who gets to decide what the Constitution means. The 9 justices now carry that weight alone. The Supreme Court has not yet issued its final ruling, but the oral arguments revealed deep skepticism toward the administration's approach. The constitutional text, historical record, and over a century of precedent all point toward a broad understanding of birthright citizenship. More fundamentally, the justices from both ideological camps appeared troubled by the idea that any president could redefine constitutional protections through executive order alone. The legal lesson is clear. Some rights are embedded in the Constitution precisely because they are meant to be beyond the reach of temporary political majorities and individual executives. The 14th Amendment was written by people who had seen citizenship denied and wanted to ensure it could never be so easily taken away again. Whatever the court ultimately decides, this case has already demonstrated that the meaning of those 28 words remains as contested and consequential as ever. If you found this constitutional battle fascinating, subscribe to Court Decoded. We break down the legal cases that shape American rights every week. Hit the notification bell so you never miss a verdict.